everybody, Kirk Tousaw here with another edition of Legalese. It's been a while since I put a show together. I'm sorry about that. I'm definitely going to try to put these out a little bit more regularly. If you're tuning in for the first time, I'm a lawyer with Conroy & Company in Abbotsford, BC. I actually live on Vancouver Island, do a lot of work in the lower mainland of Vancouver. And I do a lot of work around marijuana issues. I'm also the executive director of the Beyond Prohibition Foundation, which operates the website whyprohibition.ca, and I encourage you to check that out if you're interested in marijuana policy reform. Today I'm going to talk about three legal situations, one municipal, one in Ontario, and one court challenge in British Columbia. Give you a bit of an update about what's happening with my friend and our hero Mark Emery, and then talk a little bit about recent events in Vancouver. The first thing I want to talk about is a situation involving the municipality of the district of North Vancouver. Just north on the north shore of Vancouver, the district has begun the process of passing a bylaw, a zoning bylaw, that would essentially prohibit anyone from opening a compassion club in the district. This bylaw comes in response to news reports that a marijuana dispensary for medical purposes was going to open within the district and appears to be targeted against that particular dispensary. Now, the matter went to public hearing just the other day, and overwhelmingly the public came out in support of the dispensary and against the bylaw. There were very emotional moments. People told personal stories about how medical marijuana really improved their quality of life to the point of really being able to regain some of the enjoyment that they were getting out of life. And those stories were compelling. In the face of that kind of real honest truth about medical marijuana, it became apparent that the bylaw was based on really misinformation, untruths, things that just don't happen around the dispensing of marijuana for medical purposes. And so the next hearing is this coming Tuesday. It is not open to the public. It's open to the public, but the public can no longer comment on the issue. And of course, we urge the district not to act hastily in the face of all the information they've been given, but rather to enact a compassionate bylaw that allows critically and chronically ill residents of the district of North Vancouver to have safe access to medical cannabis when they need it. Another case going on here in British Columbia is one that I'm acting as counsel on. It's a charter challenge and a common law challenge to the prohibition on trafficking in THC. The facts are essentially that a baker, my client, for the Cannabis Buyers Club of Canada, operated by Ted Smith and based in Victoria, British Columbia, a medical marijuana dispensary, was arrested. He was producing baked goods for the medical use of members of the CBCFC and charged with trafficking in THC. He's elected to be tried in the BC Supreme Court by judge and jury. We are going to be mounting a charter challenge to the MMAR and the Controlled Drugs and Substances Act, which do not allow for the production of resins or baked goods or any extractions or any of the many different ways that people ingest marijuana for medical purposes. And we are also going to be making in front of a jury the common law defense of medical necessity. That is something the jury is entitled to rule on. We have a tremendous amount of confidence that the good people of Victoria, British Columbia understand that when the federal government doesn't give you the option to even have a cookie or a tincture or cream to treat your symptoms and your conditions, that the courts need to step in, or a jury needs to step in, and certainly we have every hope of an acquittal and a victory on the charter challenge. The third case is in Ontario. It's R.V. Murnagh, M-E-R-N-A-G-H. Matthew Murnagh charged with possession of marijuana and production of marijuana. Raised the charter challenge along with his lawyer Paul Lewin, did a fantastic job, and recently obtained a very detailed and comprehensive opinion from Judge Taliano of the Ontario Superior Court, ruling that the entire marijuana medical access regulation scheme violated Mr. Morgentaler's charter rights, and that therefore the entire scheme was invalid, and indeed the prohibition on production and possession of marijuana was invalid. The government was given 90 days to fix the deficiencies in the program, which boiled down to their essence are essentially that people that qualify for marijuana, that find marijuana give them medical benefit, are effectively prevented from accessing the legal protections of the program. They can't get their exemptions because doctor participation in the program is so low. It's analogous to the 1970s R.V. Morgentaler situation, in which women were technically lawfully able to procure an abortion, but because of the nature of the regulatory scheme, were practically unable to do so. And that's certainly the case in Canada. We have about 1 million medical marijuana users. Only about 10,000 over the last 10 years have been qualified for licenses to possess and or produce marijuana for medical purposes. And so Mr. Morgentaler, along with the help of many brave people and witnesses, mounted a case, got an incredible victory. Government was given 90 days. There's a hearing before the Ontario Court of Appeal June 22nd on the government's request for additional time. Now on the heels of this, the press is reporting today that Health Canada is commencing a regulatory review of the system with an eye towards contracting out the production of marijuana and possibly even the processing of licenses to possess it to third-party contractors, and taking away from patients the right to grow it for themselves or to have someone compassionately produce it for them. It's really hard to describe how twisted, how incredibly wrong-headed the government's plan is. This will not help access to medical marijuana in this country. This is not the direction to go in. Certainly, efforts by Health Canada to increase the number of lawful producers across Canada, increase variety available to patients, to increase their choices, that's a good move. But to do that at the expense of the patient, taking away the right to grow for yourself or to have somebody produce for you, is absolutely incomprehensible to me, and certainly is going to lead to another decade of litigation and to having a lot of people suffer needlessly. It's time for us to understand that this is not what we should be doing. We should be opening up access to marijuana for medical purposes. We should be, in fact, ending marijuana prohibition so that everyone can have access to marijuana without fear of criminal sanction. So look at what's going on in the law in those cases. I'll also talk about my friend, my hero, Mark Emery, currently still incarcerated, recently had his plea to the U.S. government to transfer him back to Canada rejected. He doesn't have an opportunity to reapply for 2 years, which means he's going to spend an awful lot of time in the United States, in prison. See the website freemark.ca for information on that. Write to Mark. He enjoys getting letters from all kinds of people. He enjoys the discourse. Send him books, send him magazine subscriptions. There are all kinds of ways that you can help Mark, and they're all listed for you at the website freemark.ca. We're still pursuing some fronts. Access to Information Act requests have been sent to the U.S. government. Access to information requests to the Canadian government because there was a couple of things around the denial of the treaty transfer that were unusual, and we're trying to get to the bottom of that. But for now, it's at least 2 years before he can apply again. We need as much support as possible. We need to keep the pressure up on the Canadian and U.S. governments, and freemark.ca will tell you how to do that. Finally, I really couldn't do a broadcast today without talking about Vancouver last night. They lost the Stanley Cup, which was disappointing, of course, to the people in this city and the fans of the Canucks. But what I think disappointed everyone, even more than that, was the behavior of people after the event, the rioting, the looting, and the general mayhem. And, I listened to a lot of news coverage today, and there's a lot of people blaming a lot of other people and factors. Of course, the people that engage in the activity. Police response has been blamed. The lack of preparation has been blamed. The bystanders have been blamed. There hasn't been a lot of talk about one of the things that really fueled that rampage, and that's the consumption of alcohol. I'm certainly not opposed to the consumption of alcohol. I like a good cold beer on a hot summer day as much as anybody. But it is indisputably the case that overconsumption of alcohol fueled a lot of the rioting, may in fact have been the primary reason for the rioting. Certainly there was a different scene at the BCMP Vapor Lounge where people were peacefully enjoying cannabis, although disappointed. There wasn't any kind of the looting or the rioting that was going on out in the streets just a few yards away. And I say this because I know that if there had been even a small incident, even 2 or 3 people on methamphetamine, for example, smash out a few car windows, it would have made the front page of the newspaper. And the article and the tenor of the articles would have all been about blaming, of course, the people engaged in the behavior, but talking about cracking down on methamphetamine, talking about ramping up the drug war as a result of things like this. There's not any of that kind of vile directed against alcohol, and nor am I suggesting that alcohol should be prohibited, but I think we got to understand that it's a drug that causes a tremendous amount of social unrest and distortion, and last night was a huge example of that. And we have to lay blame where blame is appropriate to be laid. At the same time, we have to realize if we gave people other lawful options for recreation, like marijuana, a much safer, much more benign substance that doesn't impair your judgment in the way alcohol does, it doesn't make you inclined to take risks the way alcohol does, it doesn't feed anger the way alcohol does. If we gave people that option, maybe some of them would take that option, and we'd all benefit from it. And so it's just another example of prohibition incentivizing people to make bad choices. So obviously we wish for a speedy recovery for anybody injured in the rioting, and we hope that it doesn't happen again. Thanks for tuning in. If you want to know more about what I'm doing, please check us out at whyprohibition.ca, kirktusaw.ca, and freemark.ca. And while you're on the internet, check out cannabisculture.com, where you can see all kinds of articles and buy something from the Cannabis Culture store so that we can continue to bring you content like this. Thanks very much.